Welcome back to Real Estate 101. Today we're going to continue our discussion on family law and talk about alternatives of going to court when separating. And I'm pleased to be joined once again by John Schumann of Devery Smith Frank. John, welcome back to the show.
It's good to be back, Joe.
All right, John. So when a couple is going through a divorce, do they automatically have to go to family court when separating?
Absolutely not. In fact, court is the most expensive, most time-consuming, most emotionally and financially draining option for working out your issues after you separate. There are a lot of good options to going to court. And all of those options will probably work out better for you and for your kids, except in the narrow range of times when you absolutely have to go to court. And the only time you have to go to court is when you need a judge's coercive powers to hold someone in line. So that's when you have an ex-spouse who is abusive or is mentally ill or has substance abuse issues or there's a serious power imbalance. In those situations, you may have to go to court. But in other situations, court is usually not your best option, and it's almost never the best option for your kids because it creates conflict. It doesn't help resolve conflict.
Right. Okay. So what are some of the other options other than court?
Well, there's a range of options, and start with negotiation between you and your spouse, or negotiating between you and your spouse with the help of lawyers. You can go to mediation. You can do collaborative practice. You can do arbitration. And court is at the other end. And those sort of vary from how much intervention someone has to make to your family to get you to a resolution.
All right. So how do you decide?
Well, it depends on how much intervention you need, like I said, into your family to get things resolved. If you have a spouse who is completely irrational and being very difficult or will not cooperate at all, the only thing you can force your spouse into is court. All the other ones, you need a bit of cooperation with your spouse. And then it works to how much cooperation you get from your spouse and how much help you need, you and your spouse, to get things resolved. The more you get a professional involved and the more intervention that professional has, then has to be involved to get you to a settlement, then the less control you have over your own settlement. But some people can't work things out on their own.
All right.
So you have to think realistically about, can you and your spouse work it out on your own? Do you need help of lawyers? Are you going to need a mediator? Or are you going to need someone to impose a decision? And if you need more assistance to get things resolved, then you need one of the more intrusive alternatives to court, or you may need court itself. If you can work it out or you can be cooperative with your spouse, then you don't need as much help, and that'll save you a lot of money.
Okay, so is there differences in costs?
There's a big difference in cost. Court costs at least 5 to 10 times anything else. So if you were hoping to spend $5,000 on your divorce, if you're going to court, you're spending at least $50,000 on your divorce. There's no way around that. The court process is designed to protect people and to provide a lot of safeguards, and those safeguards cost a lot of money. And there's also a lot of timing and other issues. There's a lot of work involved in court. With everything else, there's less work, and there's also you're more involved in the process. So when you're talking about negotiating, you can negotiate. It depends on how much you negotiate, how much negotiation costs, obviously, but you're keeping your costs way down. If you're using mediation, then you're hiring a mediator, but even then, that's not going to cost you the same amount as going to court, nowhere near. The same with collaborative practice. It costs a bit more because there's a lot more lawyer involvement and a lot more meetings and other professionals, but still we're talking nowhere near the cost of going to court. And arbitration can be like court, and you can have a trial. You can also use a lot of simpler procedures. And even then, no matter a more complicated arbitration, it's still going to cost a lot less than court because all the fees and costs associated with court are just astronomical.
All right, so two separated spouses can sit down and hammer something out on their own, right?
Absolutely. Spouses can work things out on their own, but at some point, and for the reasons I'll describe, they are going to have lawyers involved. The first reason they need lawyers involved is because whenever you go into a negotiation, you need to know your settlement range. What that means is you need to know what the worst you can do in your settlement or the worst settlement you should accept is and what the best settlement you should accept is. And outside of that range are things that are completely unacceptable. If you haven't been to see a lawyer, chances are you don't know what the law is and how it applies to your situation. A lot of people are surprised when they talk to a lawyer about how the law actually applies to them specifically. And we talked in another episode about common family court mistakes,
right,
or family law mistakes. And you don't want to make those mistakes in negotiations. So you need to talk to a lawyer before you go into any sort of negotiation with your spouse. So you're making an informed decision, and you're negotiating based on knowledge, not based on guessing on what's right for you.
Or fear.
Or fear, that's right. This other time you need a lawyer is at the end, when you actually write up an agreement. The Family Law Act in Ontario, in Section 56, says that in order to have an enforceable agreement, which means an agreement that a judge will pay any attention to, there has to be evidence that you understood the agreement at the time you signed it. And unless you are a professional who knows family law, which means you're a family law lawyer, chances are you don't understand the legal significance of a contract. In fact, most people don't understand the significance of legal contracts without speaking to a lawyer. So you need to have a lawyer explain to you what the agreement means before you sign it. So that means even after you've agreed to terms or general terms, you have to put that into writing, and that's one of the requirements. And then you have to understand what those terms are. And so you need a lawyer at the end.
Right. So I was just going to say, so let's say you come to some sort of, agreement. If you get lawyers to step in before the agreement is finalized, then it would be considered valid, right?
That's right. If you have a lawyer sign a certificate of independent legal advice that attaches to your agreement, then the agreement will be valid. Good. Yes, it'll be good. But you need that. Otherwise, you may not have an enforceable agreement. And if you go to court, a judge may say, I'm not paying attention to that, start from scratch, or I'm doing something different.
All right. So what are some of the things that people can do if they're having trouble working things out with their ex-spouse?
Well, on the most basic level, what you can do is you can get lawyers involved. And though that might sound counterintuitive, if you're careful in the lawyer you select and you have a lawyer who's focused on getting you to a settlement as opposed to having a big fight, then getting the lawyers involved can really help with the negotiation. They can create a bit of reality testing, give you some idea of what's realistic and what your expectations should be and what they should not be. And they can also, because lawyers are professional negotiators, help with the negotiation process. Mm-hmm. If you need it can be difficult to trust your ex's lawyer, right? And you may never be able to agree with what your ex says. And sometimes you may be never able to trust with the proposals made by your ex's lawyer. In those situations, it's often a good idea to consider a mediation. And mediation is where you have a third party, someone who's often a lawyer or a social worker in the case of parenting issues, who you and your spouse can both trust, who will come up and create some ideas or give you some guidance to how you can work together to come to a resolution. So that gives you a little bit more structure and a little bit more guidance as to how to come to an agreement. So that can be really helpful. If you cannot agree, you're never going to agree on some things, right? If you and your spouse can be respectful and say, there's things we just will never agree on. We see things differently. We cannot come to an agreement on this issue or many issues. Then you can hire an arbitrator. And even though you and your spouse pick an arbitrator, and that arbitrator acts like a judge and makes a decision, and the decision is binding.
It's binding.
Yeah. But and the decision is imposed. And so that works well. It's still, even though it's like having a judge make a decision, in that it's a third party making a decision, it is incredibly less expensive than going to court, especially if you and your spouse pick a more simplified process for the arbitration. Another process you can use if you and your spouse are wanting to get along and you can actually talk to each other, but you're just having difficulty with the negotiations, you can choose collaborative process to give you a bit more structure to those negotiations and a lot more guidance on how to have conversations with your spouse and how to work things out.
All right, so let's go back. What is mediation like?
So in mediation, you have a third party assist you with coming to a resolution. The third party, the mediator, when they mediate an agreement, the agreement they mediate is never binding until it's converted into a signed separation agreement. And in order to have that, you have to have your lawyers involved.
All right.
So a mediator cannot, by the way they are, because of the scope of their practice, they are not allowed to write separation agreements. Only lawyers acting as lawyers can write separation agreements. Now, if you're hiring a lawyer as a mediator, then even that lawyer cannot write a separation agreement. They can write down what you agreed to, but they can't do the separation agreement because then they're practicing law, not acting as a mediator.
Conflict of interest?
That's right. There's also another issue with conflict of interest, and that is a mediator is not giving legal advice. A mediator's job is not to help you understand the law or to tell you what's best for you. A mediator's job, the reason you're hiring them, is to help you get to a settlement, whatever that settlement may be.
Right.
The settlement can be bad for you, or it may be better for you to go to court than the settlement that's possible at mediation. But the mediator's job is to get you to whatever settlement. And so you really do have to know when it's a good time to walk away and when it's a good time to stay in the mediation. Because what the mediator says and does is geared only to getting you to a settlement, wherever that settlement may be. And that a possible settlement with your spouse may be outside of what your settlement range should be. It may be outside of the acceptable resolutions for you. So you cannot rely on a mediator, because that's not their job, to tell you what is best for you. Because a mediator cannot tell you what's best for you, because they're neutral and their job is getting a settlement. And if they're telling what's best for you, then they're in a conflict with your spouse, because they should also be telling the spouse what's best for them.
All right. So can you involve your lawyers in the mediation?
Absolutely, and that's often a good idea. Not only to start off, I talked about before in negotiation, seeing a lawyer beforehand to know your settlement range is very helpful. But often lawyers are very helpful at the mediation, or to have them actually at the mediation. And the reason for that is, if you've got a good lawyer who's going to get you settled, not a lawyer who's focused on a fight, then they will actually really be helpful at the mediation. Because they can walk through you. They not only get everything prepared for the mediation and make sure you have everything in line before you go, and all the disclosures made, all the documents are exchanged, all the issues of conflict are set out, but they will also help you at the mediation when there's an exchange of ideas. The lawyer will say to you, did you think about this? We should talk about this. This is a good idea, but we should probably put this on the table. And the reason that's a good idea to have the lawyer at mediation in that way is because if you come to a resolution at mediation and then you go to see your lawyer afterwards, the lawyer may say to you, did you think about that? Did you address this issue?
Right.
And I'm worried about this term and whether or not you could have done better, or you should have had it worded like this. And then you may think, when you hear your lawyer say, yeah, I should have talked about that mediation, or I should have enclosed that term. And now you go back to mediation? Or are you going to want to change the terms of the mediation? Because now you know how the term applies to you. But if you go to the mediation with your lawyer will make sure all that's involved and in the discussions. And you can actually have the lawyers at the end of the mediation sit down and write out the agreement. So you're actually getting it done at that time.
Right.
We usually find that when you have lawyers in mediation, you usually get everything resolved in less than a day, maybe close to a full day, but all the day, and then you get a final settlement, and you can be, if you've got your lawyers prepared, they can write out the agreement and you're done that day. No more going back, everything's settled, everything's done.
Okay, so what about collaborative practice? What is it?
So collaborative practice is an entirely different way of looking at negotiations. You start off by with the agreement that you're never going to go to court. And no matter what happens, you're going to keep in the negotiations. And that's important because the negotiations in collaborative practice are very different from what traditional negotiations. In traditional negotiations, it can be very similar to buying a car. Someone comes in high, someone comes in low, and you go back and forth, back and forth, back and forth. People threaten to leave, other terms. It's exactly like buying a car, right. And you work towards some place in the middle. Collaborative doesn't work like that at all. It's an entirely needs-based approach, and you have to look at what you need and what you really want. And a lot of discussion with you and your spouse about what you really need out of going forward. And that involves a brainstorming session. So instead of coming in high, coming in low, you sit down and you and your spouse talk about all the options for resolving the matters between you, and you work through how you think would work best for both of you. That can also involve having a child professional involved or a financial professional involved to help you work out the terms and understand them. But it's such a free-flowing exchange of ideas where you're talking to your spouse about things that maybe you think would never talk about in regular negotiation, and about ideas that may work out better, that you never want those discussions used in court against you if things break down. So if things break down, you and your spouse have to start off completely from scratch with new lawyers. And that's a big incentive to stay in the collaborative process. But a lot of people find that having that sort of discussion where you're having a needs-based discussion and you're not doing the sort of horse trading back and forth, but you're having a discussion about your wants and needs, is a much better way of resolving it, or resolving things. It doesn't work for everybody, and you and your spouse have to trust each other and be willing to have that sort of discussion. But where it does work, the people who do it are often very satisfied because they come up with the agreement entirely on their own.
Okay, so what about if your ex doesn't agree to anything? Then do you go to court?
Well, if your ex will agree to absolutely nothing, then you may end up in court.
Right.
If your ex and you disagree on certain things during the negotiation, and you've agreed on, the process, or you can work out things outside of court, but there are certain things you cannot come up with, and you can do arbitration. Often when we do arbitration, we do a thing called mediation arbitration, where the mediator becomes the arbitrator. And that can be helpful in that the mediator can seem to have some teeth when they're talking about what they would like to see as a settlement. Because when you're doing that, you think, well, the mediator, if we don't agree, is going to become the judge, and that he'll probably impose the same sort of result. That's not actually true, because when you go to mediation, you have a wide range of things that you can come up with as a resolution to your case. You can agree on anything that's not illegal is possible in mediation. But when you have to have someone else impose a decision, they have to follow the law and what the law says about how things should be decided. So that gives you a very narrow range of things that can be decided. So when a mediator says, I think we could settle here on these terms, that could be very different from what they would have to decide if they had to strictly apply the law as how a settlement could be. So in mediation, the mediator say, this would be a good settlement for you, but then if you both don't agree and you go to arbitration, the arbitrator may say, well, strictly applying the law, I have to do this other thing instead, because that's what the law says I have to do if I'm imposing a decision. The other thing you have to keep in mind is that an arbitrator, when they take over as an arbitrator from being a mediator, they have to start over from scratch. They can't use anything that happened at the mediation. So what happens in the arbitration can be a little different from happening in the mediation. There's whole new sets of facts, evidence of some sort, and so that can also result in different results. But having an arbitrator decide things can still be much less expensive than court, especially on financial matters. You can have a very streamlined, very summary process. You can use a range of processes that how the arbitrator decide things. And as long as you and your spouse agree that that process is fair, you can use that process and have the arbitrator make the decision. And you can literally save yourselves hundreds of thousands of dollars from going to trial in court over those same things. But if your spouse is like, I'm not agreeing with anything, I'm not agreeing to go to mediation, I can't agree with you on an arbitrator, I'm not talking to you about doing anything, then you're in court. Because in court, you can force someone to come to the table, and you can force them to participate in the process, because court has the safeguards to make sure everyone is treated fairly, even though those safeguards cost a lot of money.
All right, so do all the options you've discussed provide equally good results for both parties?
It really does depend on the situation and picking the procedure that's best for you in the situation. If you go to court or you have an arbitration, then you're going to have someone impose a decision and impose a way you and your spouse and your children are going to live your lives from now on.
Or whether you like it or not.
Whether you like it or not. Now, if you go to court, you're going to get a judge who has, especially on a motion, who may have up to 40 other things on their list that day, who has read your materials, but has no personal knowledge of your family and doesn't get to see anything more or hear anything more than what the lawyers say, no direct contact with you, no knowledge of you as a person, no way to, distinguish you from all the other cases they've heard. So the decision may not be as tailored or as good for your family as you would want. That's why arbitration, if you can't decide, can be better, because you and your spouse can pick your arbitrator, and you can pick someone whose values you think will better accord to your family, and the arbitrator can spend more time getting to know you and your spouse and your family to decide what's best for them. But even then, when you have someone who's making a decision, and the way decisions are made in adversarial circumstances, is there's no, real informal discussions, there's no warm, fuzzy discussions. So the decision cannot be the one that you would have tailored if you and your spouse had done it yourself. In negotiations, mediation, or collaborative, you and your spouse have a lot more role in tailoring the settlement that you have, which means you can focus on the things that are important to you, even though they may not appear to be important to somebody else who's just looking in. You can focus on things like kids' hockey schedules or swimming lessons or the school schedule or who does homework or whatever is important to you, and that means you can really tailor the result to what you specifically want. People who use those negotiations and are more involved in having them coming to the settlement themselves and having the terms that they think are most important in it are often much happier with the results. But if you are in a situation where you've got someone who is unreasonable or is mentally ill or is abusive, then you can't have a good negotiation with them. You have to go to court. You have to go to court to protect yourself, to protect your rights, and to level that playing field where there's an imbalance. Because if you try to do one of those negotiations and tailor things to what you want with someone who is just going to abuse you throughout or only agree to things that are completely unreasonable for you, then you really do need to have someone impose terms on you and your spouse and treat you both equally, and not allow the controlling or coercive party to have their way all the time. And that's when you need to go to court, and court would provide the best resolution in that sort of case. So what's best for you depends on your circumstances, and if you can't get a feeling for what's best for you and what would be best for you, you should really talk to a lawyer about all your options and figure out which of these options would best work for you.
All right, John, good stuff. For people watching and listening who may need your help, how do they get in touch?
Well, you can phone me at 416-446-5080. You can reach me at my website, which is www.deverylaw.ca. You can reach me on Twitter at @HumanFamLaw, and I have a Facebook page. You can find me there too.
All right, John, good stuff. Thanks for coming on today's show.
Thanks for having me again, Joe.
So there you have it. If you're looking for a top family lawyer, get in contact with John Schuman of Devery Smith Frank. Don't forget to subscribe to our YouTube channel, like, comment, and share our videos. I'm Joe. Thanks for watching, and we'll see you next time.